Good evening, ladies and gentlemen. It's 6 o'clock, so we're going to start the webinar today. On behalf of the Institute of Chartered Shipbrokers, Hong Kong and Singapore branches, it's my utmost pleasure to welcome you all to the first webinar of what we are calling the Year of Hope. Really hope it goes well this year. Having been in the shipping industry for over 25 years, mostly in technical roles on board and ashore, and more recently as a marine consultant here in Hong Kong, it's indeed very heartening to see that a large percentage of our attendees today are technical managers who are amongst the most affected party for the topic of today's discussion, which is speed and consumption claims. We have an exciting and hopefully a very informative evening ahead, led by an all-star cast of panelists. Taking charge of the proceedings today will be Mr. Punit Oza. Punit is the Executive Director of the Singapore Chamber of Maritime Arbitration, SCMA, and a Fellow of the Institute of Chartered Shipbrokers, UK. He has over 26 years of experience in dry bulk shipping. Beginning his career with the Precious Shipping Bangkok, he has worked extensively in Thailand, Hong Kong, Dubai, and Singapore with companies such as Noble Chartering, Astro Shipping, Aries Shipbroking, and Torval Claveness. He sits on the board of Claveness Asia as non-executive director. A graduate of financial management and accounting from University of Mumbai and a postgraduate in shipping, trade and finance from the Cass Business School, London. He also holds an LLB from the University of London. So without wasting any more time, I now request Mr. Oza to set the ball rolling. Punit-san, all yours.
Thank you so much, Sharad. Thanks a lot. Yes, it is a year of hope for sure. Sharad Gupta is a fellow of the Institute of Chartered Shipbrokers UK and is the education and the examination officer of ICS Hong Kong branch, for those who did not know that. Thank you so much. A warm welcome to all of you to this webinar dealing with a topic that is always relevant, speed and consumption claims. My sincere thanks to ICS Hong Kong and Singapore branches for organizing this. I'm really pleased to be a part of this event, being associated through both my positions, one being the Vice Chairman of the ICS Singapore branch, another being, of course, the Executive Director of SCMA. SCMA is very happy to be a part of this event, which is co-organized by Hong Kong Maritime Arbitration Group and also Hong Kong Institute of Arbitrators. So huge thanks also to all the organizations who are supporting this event, and a special thank you to my colleague Winnie for all the help in organizing and managing the back end of this event. This event is hoping to look at this dispute area in a holistic manner, covering the entire spectrum of the claim from its genesis to the contractual negotiation stage in form of charter party clause, to the crystallization of the claim during the operation stage, and finally to settlement of the claim in the post-fixture and execution stage. We intend to cover not only the commercial aspects, but also the legal aspects about this particular area. The key aim is to share and impart as much knowledge and as much as possible of this particular aspect of the charter party. Though I must warn here, the topic is quite vast, and obviously we may not be able to cover everything in a short span of time. The panel has experts with great in-depth knowledge of all commercial, legal, and operational issues involved in these claims. So let me introduce this august panel. First up is Mr. Jagmeet Makkar, with almost 40 years diverse commercial and technical experience in shipping. Today, Jagmeet offers services as a shipping expert, helping clients with charter party claims evaluation, independent maritime arbitrator, learning and development partner, and a ship finance consultant. Jagmeet is a graduate of DMET 7781 batch with a postgraduate in energy, trade and finance from my same institute, Cass Business School, London. His last corporate position was co-head of freight and global head of shipping assets at Noble Chartering. He's the chairman of the Hong Kong branch of the Institute of Chartered Shipbrokers and chairman of Maritime and Logistics Arbitration in Hong Kong Center of International Commercial Arbitration. Jagmeet was awarded Exemplary Multifaceted Professional of the Year 2017 at the Sailor Today Awards. So welcome, Jagmeet, to this event. Next panelist is Mr. Arthur Bowring, who's presently an arbitrator and mediator and an advisor and consultant to the maritime and commercial industries. Arthur joins us actually from Netherlands. So welcome, Arthur, from Netherlands. Arthur has a broad shipping and commercial background, which includes several years at sea as a deck officer, working as a ship surveyor for Lloyd's Register, acting as an oil and dry cargo chartering and owning broker and freight trader for a major international trading house, handling marine insurance placing and claims and working as a consultant, and handling investigative work in claims and project management. He was the managing director of Hong Kong Shipowners Association for almost 20 years. Arthur is the president and full member of Hong Kong Maritime Arbitration Group and a full member of London Maritime Arbitrator Association and a fellow of ICS and several other professional institutions. Welcome, Arthur, to the event. Next panelist is Ms. Elaine Yukai. She's a freight trader with NG Energy Management Singapore. As a highly skilled shipping professional with 13 years of work experience in dry bulk industry, she has been working with NG, a listed global energy company, since 2015 and oversees the freight desk for Pacific. She used to be the operations manager with a well-known Danish shipowner DS Norden in their Shanghai, Copenhagen, and Singapore branches. Ms. Yu has been a part of the executive committee of ICS Singapore branch for over 10 years and is currently an ICS tutor as well. Holding a bachelor's degree in maritime law, she is a graduate in international arbitration from NUS as well. She is currently the member of SCMA, Singapore Institute of Arbitrators, LMA. Welcome, Elaine, to the event. The final panelist is Ms. Suyin Anand. A lawyer by training, Suyin was a maritime disputes litigator in Singapore and Hong Kong for 14 years before moving in-house, where she's currently the head of legal for commercial arm of an Australian junior mining house. She has been actively involved with Hong Kong shipping industry for over 10 years. In addition to her legal experience, Suyin is passionate about mentorship, diversity, and inclusion, particularly in maritime industry. She drives thought leadership in these areas through her work with the young professionals in Shipping Network Hong Kong and also the Captain's Table, a maritime innovation pitch competition. She also sits on our local users council of SCMA. So welcome, Suyin, to the event. Thank you so much for helping out last minute. So as you can see, we have the perfect blend of both legal and commercial expertise to tackle this fascinatingly complex topic. Before I start, a few administrative issues. We welcome questions from the audience, which you can address to one or more panelists and post it through the Q&A tab at the bottom menu of your screen. We will endeavor to answer as many questions as possible live, but if not able to do so, we'll try and send the responses to the questionnaire by email. So let me start now by requesting Jagmeet to start off with a short presentation, setting out the main concepts and aspects of this topic, and then we can proceed to the panel discussion. So Jagmeet, the floor is all yours.
Thank you, Punit. And thanks to all the organizers, co-organizers. What I'm going to do now is just give a little bit background on Institute of Chartered Shipbrokers. And this is, I think, one of the rare moments where both the branches, Hong Kong and Singapore, together, they thought about organizing this event. And in future, we are going to do more and more events where we put together our resources, knowledge, experience for the benefit of the industry. So I'll first take you through very quickly a bit about ICS. I think most of you know about Institute of Chartered Shipbrokers. It's a professional education provider and certification organization. Institute has got more than 4,000 members, and we have a number of branches in all the major maritime centers in the world. It's like as my friend Matt Gilbert likes to say, that it's like a passport to the shipping world, the ICS qualification, which there are various ways to do it, starting from introduction to shipping, foundation diploma, moving on to the PQE. It's a very well-recognized qualification. Many of the companies have made MICS compulsory for their staff. This is, I did it in 1999 when I was a marine engineer. And every lecture that I studied or I discussed, I had a feeling of what Archimedes actually had the eureka feeling. It was giving me that sort of energy and the oomph to go ahead and learn more and more. So you can get in touch, education@ics.org.uk, and we want to hear from you. Very quickly, I will take you through what we are going to discuss today, some of it, not all. As Sherlock Holmes would say, that it's all about clarity, Watson. Party autonomy is the main thing. With regards to commercial contracts, the parties can agree to, based on the market, based on the rights and obligations, how they want to share the risk, they can enter into contract. Then availability of guidance, especially the speed and consumption claim, there is so much of material available. There's a lot of guidance from many sources, such as the clubs, as well as they themselves are available to guide the owners and charterers. Clauses, we have to remember that objectivity is far more important than subjectivity here. All the clauses, if we have them in a way that the interpretation is common, uniform, when I read it, I have an interpretation. When you read it, you have an interpretation. And if somebody else reads it, if there is no parallax, if there is no gap between the interpretation, then it means the chances of dispute are very less. Homemade clauses, let's please avoid them. Careful drafting is required to have the required effect. Otherwise, we may think we have taken all the action to protect our principal's interest, but we might find that there are a lot of problems that will start coming up later on when you don't want them to. Let me give you a sample restrictive clause. If you are a charterer, just imagine if you had this clause in your charter party. These figures are about and based on 7.6 meter draft, clean bottom, even keel, deep and currentless waters, calm sea, and maximum wind force Buffett 2, Douglas 2, and maximum sea temperature 28-29 degrees. This is amazing, a clause like this. This is an actual clause taken from a charter party. Was it, did the parties really mean it? Or this was just as per last done and it was copy pasted in there. And this is a real case again, Coral Sea. I hope many of you remember this Coral Sea's case, which was from Rio de Janeiro and the ship, no, from it was Guaiba, I think, GIT coming to East, and the ship was there for about 28-29 days. This was the clause. There was nothing else in the charter party. There was no clause like you have in NYP 2015, clause 30, hull fouling. There was no hull fouling clause, absolutely nothing. In this NYP 1946, that was the amended one, it made the warranty, continuing warranty, by saying throughout the currency of this charter, the owners warrant that vessel shall be capable of maintaining and shall maintain. The only defense owner has over here is Buffett scale 4 and Douglas Sea Strait 3, and not against adverse current. There is nothing else. And the ship was there for 29 days. The hull was lightly fouled, propeller was badly fouled, and owners lost the case, hundreds of thousands of dollars. So it's almost like a blank check, giving somebody a clause like that without sufficient defenses and no hull fouling clause. So we have to be very careful when we do the negotiation. Now, I'm just going to quickly build the some of the basics during the webinar. We are going to discuss existence of a warranty. Is there a warranty in the charter party, or it's just without obligation? We are going to look at it in detail later on when we discuss this matter. I just want to bring it up. Good faith or the lack of it, how does that affect? And can you prove that there was bad faith? How difficult it is, so we are going to look at that. Upon delivery or continuing warranty, qualification, condition, basically what we are talking here is the defense available. Good weather, is there mention of good weather in the warranty clause? Yes, no. If it is there, is it definitive? Is there any numeric numbers attached to it? Then what about current, swell? There are so many conflicting awards regarding this. We are going to see some of them later. So that clarity is so very important. Then the other clauses which can come to the defense of the ship owner, hull fouling clause, bunker quality clause. NYP 2015, the bunker quality clause is pretty good. if you look at it, how it splits it. Then slow steaming are allowed to deviate. Obligations, now here the obligations, they extend not just the owner and the charter, from owner directly to the holder of the bill of lading. It talks about unreasonable delays, and there could be issues over there. About or double about. Noon to noon. This is a very interesting case, Ocean Virgo. Don't try to put anything in the charter party which is not there. An arbitrator cannot say noon to noon 24 hours when it is not actually mentioned by the parties. So these are few things which are quite important. Then we are going to look at the evidence, quality of evidence. That is something very important. One of the questions we received during the registration talks about what all documents are required for an owner to fight the case. Number one is just quality evidence. Rest we will discuss later. Then discrediting the ship's log entries. Have to be extremely careful. If nothing is mentioned in the charter party that there is a binding evidence to be applied, then general tendency is to go to the look at the ship's logs, deck logs to look at the evidence, unless it is going to be discredited. Now let's quickly look at this, because of this applying double benefit to the owner, you reduce the charter party speed by half a knot, and then you increase the consumption by 5%, changes the whole game. I've just applied, assuming it's a clean hull, I've applied the propeller law. It basically turns to 15% benefit on the consumption you're giving. No, that's all fine. But if the parties have agreed to have double on the speed and double on the consumption, then who are we? We have to follow what the parties agree. At that time, no sophisticated mathematics or propeller law will come through. This is what the parties have agreed to have double applied, we will apply the double. A bit of very difficult to read, but I'll just explain to you. On the left side, you will see a table. It's a voyage estimation calculation, which is the warranted speed and consumption. My freight rate comes to 8.4. This is delivery Singapore and from Adang Bay coming to Ennore, east coast of India, to get $13,500 at say $450 per ton on the low sulfur fuel, $8.4. Now, if I make my speed reduced by half a knot and increase my consumption by 5%, it is $8.7. So I am losing 29 cents per ton on a very short voyage, which is 20 days voyage. Just imagine what the result would be if it was delivery Qingdao for a cape going to Tubarao and coming back to Qingdao. This is something which is quite interesting to know. Finally, from my presentation, this last slide is something that I love. Many a times people ask me this question when I conduct my courses, but arbitration awards are there. Are they not binding? No, arbitration awards are at best persuasive. They are not binding. And especially the speed and consumption clauses, we have very restricted case law. Majority of the decisions are made based on the arbitration awards, and they are at best persuasive. So that is why for the same thing, two different arbitration tribunal can give bit different results. And with that, thank you very much. Punit, over to you.
Thank you so very much, Jagmeet. I think this was very good setting the stage of what we want to discuss going forward. I think it's a great discussion and I look forward to that. So let me start from the start. The first stage is the contract negotiation stage. That's the time when you actually have the clause agreed. And I must add here that the clause is mostly relevant for, of course, time and period charters. In case of voyage charters, speed may be an issue, but consumption is really no interest to the charterers. So let's try and break down the components of a speed and consumption clause and understand what they mean legally and commercial challenges that are associated with them. Some, Jagmeet, you've already discussed and brought up in a quick way. The clause usually starts with specifying a speed of the vessel and a consumption figure at that specific speed. So usually one set in ballast, another set in laden condition. In most cases, as you mentioned, the word about is added, in some cases before both the figures. There's also is usage of words sometimes if the owners can really get their way without guarantee in some clauses. We can ask you, Jagmeet, and then Elaine, from your experience on the commercial side, what is the general understanding of the word about in this context? You already mentioned, will there be a double credit available because of a double abouts? And if it's without guarantee, does that mean that no claim can be made at all with regard to speed and consumption of the vessel? So I would love to hear some commercial thoughts first, and maybe any other panelist wants to come in and talk a little bit about the legal part of that, which we can also deal later on in detail. So maybe Jagmeet, you can start with this idea of using about single or double in the speed and consumption, and the effect of without guarantee. How does that actually impact the potential of having a claim?
Thanks, Punit. I think as far as double or single about is concerned, I showed you the mathematical calculation. What it comes to basically is what the parties have agreed. If the parties have agreed about to be put before speed as well as before consumption, so in my opinion, my view, that has to be applied. You have to take care of respect the parties' will, and this is what they have done. Coming to without guarantee in good faith. Now, if the vessel's description, Punit, is without guarantee, then there will not be any warranty, and hence probably no basis for a performance claim. There would be very heavy burden of proof on the charterers to establish lack of good faith. Lack of good faith is not very easy to establish. Say, for example, a vessel has been consistently underperforming even before she came into your charter. How will you find how she has been performing in the previous voyages? Let's assume you are able to find out, and you find that she has been consistently underperforming. Then possibly, yes, you may have a claim. But then that takes us into the realm of misrepresentation, be it innocent or it is fraudulent. I think that maybe in the next seminar or webinar.
Probably. But is there any specific amount or a percentage margin which is talked about for about? The minute you have the word about before the speed, is 0.5 knot a given? Is 5% a given before the consumption? Is that something which cases point out to, basically?
Yeah, that's Elaine would like to take that, or should I continue with that one?
Elaine, do you have any thoughts on how the word about actually impacts the calculation from a commercial and practical perspective?
I would say from commercial point of view, if it has been stated clearly in the CP that about 13 knots speed and about 28 metric tons consumption, that means about will be taken account twice. But very often now we see that both owners and the charterers, they like to use the Excel sheet. Like they put a laden speed, they put a ballast speed, and everything put in the Excel sheet. And only after they go to the Excel sheet, they say about, means half knot on the speed and 5% margin on the bunker consumption, which I personally don't really like, because then it gives a unclear definition whether this about should apply to one side or on both. So that one I want to mention.
Okay.
Thank you. I'll just add something to that, Punit. Now, this 5% and half a knot, it's not cast in stone. It's not something there is a case law on it. No, it is not there. It's just a general understanding, and people are using it. The arbitrators are using it. But there are cases where 4% has been used on fuel consumption. 0.25 knots has been considered for the on the speed. So if we look at this case called Albida, in Albida, what the decision made was that how you come to that tolerance will depend on the size of the ship, the draft of the ship, the trim of the ship. But this whole thing, generally, when the arbitrators are looking at, they are using half a knot in general and 5% over there, even though there is no case law which says that you have to use half a knot and 5%. Sure. Arthur, anybody can
Arthur, do you have anything to add into this, obviously from your experience? Has the word about
No,
have
I think
a definite meaning?
I think it's fine. I think it's fine, Punit. Jagmeet did give reference to the Albeda in the Court of Appeal, which I think is quite an important case on this, where it was decided that the court was not able to give a definitive rule on what the word about meant. And it is dependent on the ship's configuration, size, draft, and trim, etc. So it's really something for the arbitrators to assess. And in fact, in the Albeda, it also mentions that the arbitrators don't have to give a reason for their assessment, but of course, it would probably be good practice for them to do so.
Thank you. And obviously, this needless to add that it's better for the parties if they really want to clarify this, they have to make sure that they put it in the clause what they mean by this about. If they can clarify that, that will hopefully create a better and clearer clause going forward. Now, the next part of the clause, of course, is the warranty only applying in good weather conditions. So what does good weather actually mean? What kind of parameters are we talking to? If no mention of good weather is there, does it mean that basically the speed and consumption warranty applies on all conditions? And of course, there is this discussion on Beaufort Force and Douglas C. State. And I think there is already a comment here from one of the attendees, a very esteemed one, on the use of the Douglas C. State as an obsolete scale. So I would really like to get maybe Arthur to come in, because obviously this is something that he can comment on in terms of what is good weather all about. And then maybe from a commercial perspective, a little bit of, say, Elaine and Jagmeet coming in as well on that. Yeah, Arthur, maybe you want to start and comment on this?
Well, just very quickly, Punit, what I'd just like to do, and I've already answered a question from Brian on this, is refer to Brian Williamson's excellent papers on the Douglas C scale. It is, I think, a comfort blanket that brokers like to use in order to put Douglas C scale in there. It's not necessary. The Douglas C scale does not have wave heights within it. And anybody who's done any research on this will see that it's actually not applicable. It's not being used properly, and seafarers are not trained in assessing weather conditions on Douglas C scale. So much better just to drop the Douglas thing. If anybody would like a copy of Brian's papers, I'm sure I can make them available, or even Brian himself. But it is something that's redundant and shouldn't be used anymore. On the good weather, of course, people do use Beaufort 4, which is fine. That is something that mariners are trained to assess and to actually log down in the deck log. So that shouldn't be.
Sure. And on the commercial practice side, Jagmeet, would like to add in what is normally seen in charter parties and how can we be more clearer in charter parties in this regard?
Yeah, Punit, I'm going to put on my naval architect hat. So very quickly, you know, a ship is basically a free floating body with 6 degrees of freedom, right? So there has to be some sort of reference to which then you go ahead and measure whether she's performing or not. This is exactly what you do in a shipbuilding contract. So there it is a guarantee. Here we are talking about warranty, right? So there you have a range of liquidated damages until it gives you the chance to cancel the contract, which is not here in this case. However, like in the shipbuilding contract, you specify what would be the condition of the sea, the wind. Similarly, it's always good to have that over here. But then the law is going to look at it a bit differently. If you don't mention anything in your clause, you don't even mention good weather, then how it is going to be looked at by the people who are going to finally decide the case? Well, the owner was so confident about his ship, that ship is going to perform, doesn't matter which weather. So then this good weather won't come in and ship would be expected to perform come what may. And if you mention good weather, but you don't basically put the quantum in there, you don't put the numerics like the Beaufort scale 4, or I still would go ahead with Douglas C State for the time being and for this seminar, Or say, for example, you can have a significant wave height of 1.25, let's say, for example, or whatever the parties decide. If you don't have that, if you only put good weather, then the way things would be looked at by the people who are going to reconstruct that part would be, okay, Buffett scale 4 and Douglas C straight 3. So that will come in. Current and swell may not come in if it is not specified by the parties. But if everything is mentioned, then perfectly fine. And the question that you said, how to avoid these are avoidable issues. I mean, what stops you from making a proper contract, proper clause, put good weather there, mention what is to be done, whether it is in terms of the speed, wind speed, it is swell or sea condition, etc., all that can be done. Yep.
Right, but this is, of course, this brings you to exactly the same thing with regard to the question of how do you define them, because as a layman, you're not really used to these terms and conditions in a big way. But in terms of having a clause, maybe Elaine, do you want to add in as well? What is your experience from your time as an operations manager and even now in terms of what do you see in defined as good weather in your clauses? How do you see the ambiguity being resolved, for example?
Generally, what we will put in the charter party for the definition of good weather will be max Beaufort 4, Force 4 and the Douglas C scale 3 max with no adverse current and no influence of swell. That is the most commonly used wording. And sometimes during the commercial negotiation, we will see charters always want to delete with no adverse current and no influence of swell. So to make the definition of good weather even wider. Sometimes we also see charters want to define what is good weather days and what is good weather. I think later on probably we will discuss more on the good weather days. But during the negotiation, we already see like some charters or owners, I think owners want to be more specific, like in case the good weather time the bad weather time exceed 16 hours in the day, then this day should not be considered as a good weather day and it should be excluded from the performance audit report later on, such as something like that. That's my experience with a good weather discussion or negotiation during the charter party.
It's always a balance, I agree, because it's between how much can you go into detail of this. So, I can bring you in a little bit here and just try and tap into you from your previous experiences as a lawyer. And in terms of, have you seen any cases where you actually had instances where the charter party clauses have been clearer than usual clauses in terms of good weather? Can you offer any guidance on that?
Well, yes, I think through my career and as, a lot of the esteemed attendees as well as my fellow panelists have seen, we've probably seen a variety of clauses in charter parties, some of which are clearer, some of which are less clear. I am aligned with, I think, a comment that Arthur made in response to a Q&A. Clarity is always better. But what I've observed is sometimes people are nervous about clarity. Even if owners want to have more clearly defined days, to your point, some of them might think, well, we're only lay people. What do we know? Are we giving away too much? Charterers might also say, well, are we committing too much? Are we giving away too much by relying on more clarity? So even though the benefit of clarity is known because it reduces the dispute, it is what it is. If you agree 0.5% and 30 knots or whatever it is, it's clear there's no dispute over what those things can mean. People just in the negotiation state tend to have an adverse effect to clarity. I also think I want to just highlight one point, right? Yes, people are lay people, operators are lay people. They may not necessarily know the technical capabilities of the ship, but at the end of the day, there is an underlying shipbuilding contract. It was built to certain specs. So there is a way of identifying how your vessel can perform. Do we want to refer back to that? Should owners be referring back to that when agreed speed and consumption clauses is one question. And the second one is a very commercial question, right? It's how much risk do you want to take? What
Sure.
dollar amount that you're prepared to give away in the in the course of performing your charter party. And I think ultimately at the end of the day, that's what the negotiations fall down to.
Absolutely. So I appreciate that. I think the commercial discussion is as important as the one subsequently, which is going to be the legal one. And of course, I would just like to also try and point out or ask the panelists about some of the unusual terms which come in. Jagmeet showed in his presentation the idea about the speed and consumption warranties only applying in a certain temperature of the water, even keel, clean bottom. It's quite a lot of these things that are ambiguous. So avoiding them, of course, can be a commercial challenge going forward. Another thing, of course, is the weather routing company and its parameters. We can discuss a little bit more on that in the later stages, but we have to kind of move on to the next stage, really, in terms of how this claim crystallizes. So let me start with asking author whether this term, and both you, Suyin, as well, as whether this term is a continuing warranty, or more importantly, is it still a warranty or a condition? What can kind of make it such an important thing that somebody can walk out of a deal or terminate the contract? Or is it something that needs to be specified in the contract that it's a continuing warranty? You can just clarify this point, because I think this will be important to set the tone for the future discussions on the next two questions that we are talking about. So maybe I start with you, Suyin, about the fact that whether it's a warranty or a condition, and whether it's automatically a continuing one. And then maybe Arthur can chip in with some thoughts on his side. Yep.
I think I'll answer the second part of is it a conditional warranty? I think it is a warranty. Again, it depends on the drafting, but more often than not, it's drafted as a warranty. Whether or not it is a continuing warranty, again, I think unless expressly stated that it's continuing during the course of for the entire duration of the charter party, it is more likely than not a continuing warranty. And it's actually important, sitting in the charterer's position right now. And I think it's a really good question, because I would say oftentimes people might miss this clause. But if you are a charterer and you're chartering in a ship with a view to trading it and sub-chartering it out, you would want to have a continuing warranty in your head charter, so that in the event you sub-charter your vessel out and you face a speed and consumption claim, you are at least, you know that you can be in a back-to-back position with your head owners. I think it's something which a lot of charters probably don't think about when they are negotiating their time charter party. But I'll be interested in Arthur's view.
Absolutely. Arthur, you can chip in on this side. I think whatever insights you have would be quite interesting, probably reaffirming Suyin's position, but also adding something in. Yeah? You're mute.
You're mute.
Classic COVID statement.
I know.
Now
there we go.
Yeah.
Okay. Sorry about that. No, just to reconfirm what Suyin said, speed consumption clauses, unless they're accurate, if there is a material misdescription, then charterers are entitled for damages for losses suffered as a result of the misdescription. I think Suyin would agree with that. And of course, the continuing warranty, you have to actually state that it's a continuing warranty. And I fully take Suyin's comment that charterers must look for the continuing warranty. If you're an owner, try and make sure it's not there, but then it's only valid at the time of the contract or the time of delivery, depending on the charter party terms.
Thank you. So obviously this is an important discussion from commercial perspective as well, that charterers and chartering people must keep this in mind of trying to get a continuing warranty. We'll have another round of discussion on this, especially when we talk about NYP 2015 at the end of the session, nearly at the end of the session. But one of the issues I would like Arthur to elaborate from your side is, what is the key difference between a performance claim being different from a simple off-hire claim? Because the treatment of a performance claim is very different compared to a off-hire claim in general. So how would that actually work? And if that case, you can just highlight that, that'll be interesting for the audience. Yeah?
Okay, I'll try and keep this very short. Off-hire clauses within charter parties give very specific conditions for the ship to be off hire. If I refer to the 90/2015, which I hope everybody is now using, if you look in that, if upon the voyage the speed be reduced by defect in or breakdown of any part of a hull, machinery, or equipment, the time so lost is then seen to be off hire. So for an off-hire claim, you have to fit within that description. Now, it has been held in a couple of cases that where the ship was fouled on delivery, then that was a defect in the hull and therefore was an off-hire claim. It's also been held in another particular case where a claim for speed and consumption was made under the off-hire clause, and it wasn't, in fact, off-hire. Because of the time that was passed, the charterers were not able to represent their claim, and in fact, it was time barred. So it is very important that when you look at this, you look at your off-hire clause, you look at the conditions under that, and see whether the speed and consumption claim would fall under that within the specific parts of that clause, or whether it is in fact a speed and consumption claim, which then fits differently under that different title. Thanks.
Right.
Yeah.
Sure. If any of the other panelists would like to add something into this, yeah, Jagmeet, go ahead.
Yeah, in terms of treatment of the off-hire claim under the off-hire and the claim under speed and consumption, you know, what we talk about the compensation for the reduced bunker consumption, if there is, if it is a claim under the off-hire, then you won't get that benefit. So the calculation is very different under the off-hire claim and the speed and consumption claim. I agree with Arthur when he says that for a speed and consumption claim, to be a claim under off-hire, it must be one of the events which must be mentioned under the off-hire clause. But the treatment, the calculations would be very different between the two. The owner is going to be losing out more if it falls under off-hire vis-a-vis if it is a speed and consumption claim.
Sure. Thanks a lot. I would just like to tell the audience that I have seen a lot of questions, a couple of raising of hands. We will come back to you towards the end of the webinar. But continuing with this flow here, you mentioned a little bit about credit for the reduced consumption of bunkers, for example. So I just wanted to ask you, Jagmeet and Arthur and Suyin as well, what is the legal position of netting of savings in bunkers or time against loss of time or excess bunkers consumed? So if you assume that you actually have time lost, but bunkers saved, can the owner automatically net off one against the other in order to reduce that claim which the charterer is making? Or does he need to write a set off provision like this into the charter party clause? Is it an automatic right or does it need to be written in? That's the question.
I have seen some of the clauses where it is very clearly mentioned, but I may be wrong on this one, but I would like Arthur and Suyin's opinion on this. In terms of equity, in terms of being fair, I think it is English law. I'm not 100% sure, but I would wait for that. In terms of equity and fairness, if you're claiming against someone that he has used more number of days, but because of having the ship going at a little bit less speed, because you know that consumption is reducing parabolically compared to the speed. Sure. So there is a possibility owner will save bunkers on that. So that credit should go to the owners. But it's always good to mention it clearly in the clause if you intend to do that.
Right. Suyin, go ahead.
So I believe that I do agree with Jagmeet that it's a matter of equity to give the set-off, that's the right thing to do. But I also believe that there is case law on this point, which says that the owners can set off the bunker under consumption against a claim for damages. So credit can be given for the under consumption. So I think in that sense, the law kind of mirrors what the ethically right thing to do is in this one particular instance.
Okay.
Arthur?
I agree. I'm not going to expand on this. We don't have too much time, but I agree with Suyan's comments.
Okay, so that means that the setting off will be equitably allowed from the legal perspective, which is good to know as well. One area which is hugely and a vast topic is the weather routing companies and their role. I know we are not having that much time on our hand to deal with it in substantial way, but what is it? Normally, a normal commercial clause, if the charter really has his way, he will push it through and says whether routing companies' findings will be binding on both parties. What kind of conflicting evidence that can the owner then present, or opposing evidence that the owner can present? What value does the vessel's deck logs have in this case? What will the actual value of vessel's deck logs be in case the charter party clause says that the weather routing company's findings are binding? How is it in practical terms? That I would like to hear from Jagmeet and Elaine. And what is it in terms of legal terms? What kind of defenses does the owner actually have if he is presented with a claim over and above using the deck logs and maybe something else? And there again, Arthur and Suyin can come in. So maybe a practical commercial thing first about weather routing companies and their performance data from Elaine and Jagmeet, and then Arthur, Suyin about the legal part of it. Elaine, do you want to start? Talk
Yes.
a little bit about the weather routing company, how practical it is to use their data, and how do you find this as both as an owner and charter? You have been on both sides of the fence, right?
Yeah, I think it is quite common now for charterers to appoint the weather routing companies to provide a guided route for the ship and also to monitor the performance of the ship. While later on, if charterers want to put up the claim against owners against underperformance, and also they will rely on the weather routing report. But the owners can always rely on the deck logs, and they can also argue whether the weather routing reports is an independent weather bureau report. So in that case, have to go back to the CP agreement, what has been agreed, that what should be the final binding evidence in case there's an underperformance. As far as I know, now the courts and the tribunals tend to use the vessel deck logs as the final binding evidence in case there's no clear agreement in the CP, because the mariners are the one who is actually on the ship and can really monitor the actual conditions of the weather at that point, while the weather routing company, their data were collected basically from the weather buoys and from the satellite. So sometimes the buoys might not really can monitor the exact position, weather condition, where the ship, the precise location is. So that is my point of view. Let's see what others say.
Yeah. Go ahead.
Elaine, I agree with you. I mean, starting point is always the charter party. And sometimes what happens is, even if you mention weather routing companies' data to be binding in the clause, but you don't mention the calculation. So that's again, a problem. You can have the same data and very varied calculations. Basically, you can skin the cat in so many different ways. And then again, you start with the dispute over there. So that's a very, very important point. And if the charter party is silent, as you very rightly mentioned, the reliance would be more on the ship's deck logs, provided the deck logs are not discredited. This is something which is extremely important. There was one question in the chat box: if the owners, people on the ship keep writing bad weather every day before scale 5, 6, 7, then what happens? See, just writing the 5, 6, 7 in the logbook or on the deck log will not help in terms of comparison with other evidence that you may collect on board the ship. Your propeller slip, you could have a speed log, you could look at the speed over water, any ballast exchange, and all those things. There are a number of ways as an arbitrator or as someone who wants to find out, you can actually check. So it's not that easy that you continue to write. And nowadays with AIS and ECDIS, it's not very easy to keep fudging the report. So it's better not to do that. So if that is good and there is no discredit and the CP is silent, then yes, the approach would be to give due credit to the deck logs, not deck abstracts, please let's keep that very, very clear in mind, because the weather is recorded every 4 hours. Speed is recorded after every 2 hours. So when you look at the abstract, you get average noon to noon, whereas the deck logs will give you good information and you can very clearly monitor how the weather has been. Yeah.
Absolutely. That's a very valid point. So Arthur and Suyin, elaborating on this and also trying to encapsulate a little bit more of any other defenses that the owner might have if he's presented with a claim. That can be quite interesting for the audience to understand. What defenses does the owner actually have if he's presented with a claim other than just saying the deck logs and what we've just discussed? Any other defenses?
So the two that immediately come to mind if I were an owner would be I'd start questioning the quality of bunkers that have been supplied by the charterist to the ship. And secondly, if she's been trading around for a while, bottom fouling, which is just a natural consequence of following charter's orders. So these could be two additional defenses available to the owners. And I just want to pick up just one point that Jagmeet mentioned. Fudging of the weather report aside, sometimes, and I was just having a discussion with the P&I Club claims handler before this presentation, sometimes the weather routing companies just get the clauses wrong and put in the wrong parameters and make calculations based off the wrong parameters. Now that is may not necessarily be fudging. It could just be taking a previous report that they prepared for another vessel and just changing the calculations around. So, that's the other thing to do, is to actually read the weather report instead of just the conclusions, to really be satisfied that the report is accurate.
Sure. Absolutely.
Can I add to that, Punit? This is very interesting point. This is exactly the case of Ocean Virgo was. You see, what happened in that case, if the arbitrator has to look at the which days or which periods are good weather or which are not good weather, then up to that stage, what was being done before that? Did the owner check the report which was submitted by the weather routing companies through the charterer? A number of periods were found they were not complying with the defenses which were there in the charter party clause. So that is something to remember. And then, of course, different ways of calculating and number of ways the mistakes can be made. That's something we have to keep in mind. Yeah.
Absolutely.
Yeah. Please allow me to add one comment on top of that as well, because it's generally a common practice that we have the wording vessel entitled to use more diesel oil at the narrow, shallow, busy water area, canals, in and out of ports, and engine starting, stopping, right? We always have this. And sometimes we do see, like when weather routing companies, when they do the audit report, they don't automatically exclude these shipping time, especially talking about, take example of the Yangtze River in China. Generally in the peak season, it will be always busy water, a lot of pilots, a lot of ships there, and the weather routing company just will generally they will just calculate until the vessel reaches the port. But the whole Yangtze River, that could take 1.5 days, 2 days sailing in the busy water area. So yeah, when we receive this kind of audit report, we need to be cautious and carefully look into the details.
Absolutely. So I think there are some very practical points here, but I must say they're a bit technical as well. But we do have a little bit more clear understanding of the claim. I will jump across to the next issue, because I think Arthur has just mentioned he's kind of in agreement with what has been said so far. Effectively, now that the claim has crystallized, you need to resolve it. And the resolution of the claim, of course, is because the parties don't see eye to eye in most cases, if not totally, but in partial terms. So I would just like to mention here, just to fly the SCMA and the HKMAG flag, as well as the arbitration flag, saying that most of the time the disputes are fairly small amounts, and the best way is to resolve them with arbitration. All the major arbitration centers in the world, LMA in London, SMA NY in New York, SCMA in Singapore, HKMAG in Hong Kong, all have small or shortened claim procedures, which are very ideally suited. They're quick, they're cost effective. So this is just to fly the flag here about arbitration. and the fact that it plays a major role in resolving these disputes as well. Not surprisingly, a lot of times parties settle the claim and split it one way or the other. And we still have had a few disputes which go further out, who have not got the settlement through. They go to the arbitration, and in some cases, even all the way to the courts. So if I can just request Suyin, Arthur, and then Jagmeet to also talk a little bit about how do arbitrators look at these cases from their experiences? Are they willing to imply terms and concepts? We talked a little bit about it earlier, but do they give benefit of the doubt to owners or charterers in some cases? Are they willing to actually differentiate cases and facts? How do they actually deal with issues like that? It would be interesting to just quickly glance through the cases. And I think with Arthur's, Jagmeet's, and Suyin's experience, it'll be good for us to take a quick journey through the awards and what arbitrators' views on these performance claims have been in past. So maybe Suyin, I can request you to start with a very brief discussion on this, please.
I'm going to be cheeky and I'm going to deflect this one to Arthur since he can get a chance to speak on the earlier question. Plus, when it comes to arbitration, he really has a lot more experience than me as an arbitrator, so I'll be interested in his views as well.
There you go, Arthur, the floor is yours.
Thank you, Punit. Just very quickly, I'm not sure I'd agree with your comment that arbitrators would take more the owner's side or the charterer's side. Arbitrators will look at the clause, they will look at the claim, they will look at the submissions, and they'll make their decision on that. Sure. There are a large number of legal decisions. There's a large number of arbitrations. There are a large number of papers that have been written on speed and consumption claims. And anybody who does a small amount of research will find these. P&I clubs have advised on speed and consumption claims and on the latest decisions we've seen on them. So quite honestly, there is a lot of information out there. There's a lot of suggested clauses or ways to deal with the various issues that have arisen. I see we have a large number of people watching this webinar. Please go back and look at your P&I club advice and information. And when you're looking at the clauses again and looking at your charter party, please try and incorporate these suggestions within that charter party. One particular thing, and I'm going to raise this again because it actually upsets me a little bit, where Douglas C state is put in charter parties, it doesn't mean anything. Douglas C state does not give wave heights. It is not a scale of wave heights. Please drop this. It doesn't mean anything at all. It really doesn't need to be there. There's a large number of other issues that come up in speed and consumption clauses. Read the information, take advice from the P&I clubs, and you'll come up with clauses which can be understood and dealt with by both owners and charterers.
Yep. Thank you, Arthur. Very practical, very useful. Jagmeet, you want to end this discussion?
Yeah, I'll be very, very quick on that. I think I agree 100% with Arthur. The arbitrators definitely would start with the CP clause and what is written in the charter party, and also try and gauge if something is not very clearly written, what the intention of the parties has been. Just to use something which is going to be implied because it is written in time charters, Pamphilios or somebody, that's not going to work. So one example, again, same example, I'll come back to you, is the Ocean Virgo. I mean, in that case, there was in the charter party, it was not mentioned that good weather day is defined as noon to noon of 24 hours. And matter was in an arbitration, that is how it was decided. It went up to High Court and then it came back to the arbitrator. It was sent back. That you cannot put in something which is not there. So that implying things in the charter party, of course, if it is a statutory implying things like you have the Unfair Contract Terms Act, and if you have the Sales of Goods Act, that's a different matter depending on the contract law that is applying to a contract. But otherwise, if something is not there in a particular clause, I don't think it would be put inside by us, by the arbitrators.
Perfect. So thank you very much. I think this is a very practical discussion in terms of how the arbitrators will look at this particular claim based on some cases. As Arthur mentioned, I think the P&I Club's advice is crucial and should be looked at by most of the chartering people before they try and word a clause or negotiate a clause. As we come closer to the end of this webinar, a few aspects, practical and developing, need to be discussed. So if I can ask Arthur to share what will be the impact of the recent Seagal Charter on these clauses and these claims going forward. I think it's a very recent development, and Arthur, if you can just shed some light on that, that will be quite useful for the practitioners going forward. Yeah.
Okay, I shall try and be brief on this, Punit. The Seagal Charter, it's been lauded with much fanfare and support as a very positive initiative that obligates charterers to measure and reduce greenhouse gas emissions. Signatory charterers have the obligation then to align their chartering activities with responsible management of the environmental impact. Now, charterers then calculate total greenhouse gas emissions and greenhouse gas emission intensity of their chartering activities, and then assess their climate alignments by comparing their greenhouse gas emission intensity against what have been established decarbonization trajectories. The calculation of these trajectories, by the way, is seriously flawed, but that's something else. Sure. But the main point is that the carbon intensity is CO2 emitted divided by cargo carried multiplied by distance traveled. Distance traveled includes the approach ballast voyage, both for time charter and voyage charter. A shorter ballast voyage therefore results in better calculated intensity because you're not carrying cargo, making ships with short ballast voyages more attractive to the charterer than ships with longer ballast voyages. And the difference, by the way, you can't pay it off because money doesn't affect the measured greenhouse gas intensity. So the more efficient the ships, the better the charterer's greenhouse gas intensity. So a charterer, therefore, has great interest in ships proceeding without deviation for crew changes, stores, or other deviation for owner's account at economical speed, both for ballast and laden voyages, both for time and voyage charter parties. Charterers will therefore likely want to give steaming orders for ships on voyage charter as well as time charter. You mentioned earlier, Punit, that voyage charter's consumption is not an issue. It is if your charterer is a signatory to the Seagal Charter. And what do you have? Engine damage due to prolonged periods of slow steaming, hull fouling due to slow speeds, where anti-fouling is less effective, performance claims during the voyages if the ordered speed consumption is not warranted, performance claims in subsequent voyages. Do owners share in the benefit of bunkers saved and to be compensated for additional time on a voyage charter party? The intertanker clause allows this. The BIMCO clause is for owners to slow steam, not charterers. There's no clause yet for charterers slow steaming. Again, obligation to arrive at the load port within the laycan. If you slow steam to charterer's orders and you miss the laycan because of bad weather, who's responsible? And the obligation under bills of lading, of course, to proceed with due and utmost dispatch. And there's many other issues that are going to arrive. So I see this as being another route. I mentioned earlier that, quite honestly, there should be no doubt about steam consumption claims because we've got the clauses, we know how they've been decided. But this Seagal Charter, to my mind, will bring more claims, will bring more uncertainty until we can develop the proper clauses to be able to cope with greenhouse gas emission intensity calculations that the charterers are going to want to calculate. What they calculate, by the way, is compared against the emission trajectory. And as we saw with the Poseidon principles recently, if you're above the trajectory, you're kind of, oh gosh, you didn't do very well, did you? Only 3 people were below the trajectory. So charters are going to be under a lot of pressure to make sure that they actually meet the numbers. It's something I want to raise, and I think it's something we all need to think about very carefully, charters and owners, as to how these different things are going to be dealt with. Thank you, Punit.
Thank you so much. But does this mean that the charterers, as they try to fulfill their obligation under the Sea Cargo Charter, will put a greater pressure on the ship owners to actually perform in a certain manner, which they may or may not be able to do? And there needs to be a specific clause in the charter party looking at this particular issue going forward.
Absolutely. That is the issue. The charters have an interest, and it's a greenhouse gas emission interest, not a monetary interest.
Yes.
So it can't be offset by compensation. They have a greenhouse gas emission incentive to have the ship operating at the most efficient way possible for both ballast and laden voyages. So yes, absolutely.
Absolutely. If any other panelists have any comments on this, otherwise I'll just move on to the second last topic. Yeah, Jagmeet, you have a comment.
Yeah, just very quickly. I think initially, like every time, we will have the teething problems. We'll have that gestation period, but after a certain time, everything will fall back into equilibrium. We will have the clauses. We will have maybe 2-tier market or 3-tier market, 1 tier of market, catering to only such charters who are signatories to the Sea Cargo Charter. I think over a period of time, we'll get there.
Absolutely, but just awareness is crucial, and that's really important,
yeah.
and that's really good that Rother raises this point. The second last point, rather, is about the NYP 2015. Now, the latest time charter body is the NYP 2015. I would just like to see that it has a much more comprehensive clause in terms of speed and consumption claim, the clause number 12, which deals with not just the actual measurement or the claim itself, but also maybe a resolution mechanism in there. Is there a complete clause? Is there a clause which can be used in its entirety? Does it need to be amended? What kind of changes do we see? Some practical guidelines from all the panelists would be quite interesting. Have you used it? Have you seen any cases with regard to it? Maybe I start with you, Jagmeet, and then move on to Arthur, Suyin, and Elaine.
Yeah. Punit, I am very fond of NYP 2015, and what Arthur had mentioned that, oh, it must be now widely used. No, Arthur, it is not. It's the least widely used charter party form. We are still having 1946, where the main body is disfigured like nobody's business. All the lines, most of the lines are cut off, and you have like 100 rider clauses with that. Why I like NYP 2015 is very, very clear. I mean, it has taken into account all the contemporary practices. They have looked at all the full stops and commas and the words based on the case law developed for the last so many years, and all those things in terms of giving a uniform interpretation. I actually like this CP a lot, except for that extension of canceling. I don't know why it has gone missing. This is something which is extremely important to remember, that NYP 2015 does not have extension of canceling clause, which must be put back in. With regards to the speed and consumption clause, I would say that it only talks about the Buffett scale, talks about Douglas sea state, that should go out. We must have the wave height over there. There is no mention about the adverse current and favorable current. Since we did not discuss about currents during the webinar, let me just quickly tell you that we should also have the favorable as well as adverse current in that clause, and the swell, and how you deal with it. What is the process of dealing with it? And also preferably to put the definition of about in terms of half a knot or 5% or whatever. Just bring as much clarity as Sherlock Holmes told right in the beginning of the webinar. Yep.
Right. Thank you, Jagmeet. NYP 2015, your experiences, Elaine, on this, when you've been negotiating, have you actually had any experiences of dealing with NYP 2015 clauses on speed and consumption?
I would say, fairly speaking, this clause has been comprehensively drafted. So if I don't do shipping, I see this clause is a totally fair clause, and I would like to use it. But as an owner, since it provides the continuing warranty of the performance of ships, so I would be more cautious before agreeing to use the NIBE 2015. From a commercial point of view, I also would like to give in not really advice, but I would like to share what I think is, I see a lot of owners now, they after take a delivery of the new building, they relet out immediately on long-term charter, and all the performance data they have is basis the trial shipment. That actually leave out a potential risk for them for the underperformance claim later on in case the ship outperform or underperformed. So it will be prudent for owners in case they do not have enough historic performance data of the ship to add on one additional wording about the performance review clause, like after 1 year or after 6 months to review the performance of the ship with the charterers together and see if there is any need to alter the guaranteed speed, especially those with the guaranteed speed and consumption. So maybe it will affect the higher rate, but the high rate is always negotiable. So that is my finding of the clause when we use it.
Okay, all right. Arthur, your thoughts on the NYP 2015, maybe any cases you come across dealing with this clause? Is this more clearer? Does it need to have any additions or changes added in?
No, I haven't. As Jagmeet said, people are still working off the old versions of the Charter Party rather than new ones, heavily amended old versions of the Charter Party. Just two things on the NYP 2015. If you're an owner, the fact that currents are not mentioned means that there's no allowance for currents, either adverse or favorable. An owner would like adverse currents to be excluded and no mention of favorable currents, in which case then it's only adverse currents that's taken into account, not favorable. But in fact, the clause as it stands has no mention of currents, as Jagmeet said. Secondly, the clause as it stands has no mention of the word about. The speed consumption refers to Appendix A, and Appendix A is just listing the speed and consumption with no reference to the word about. An owner would want to put that back in, I'm sure. Just a couple of comments on that, but otherwise the clause is very comprehensive and has a lot of information on resolving speed and consumption claims, which is very.
It's a step in the right direction, but I agree with you. These are points which are practical. Thanks, Arthur. Su Yin, your experience on the 2015 clause, anything that you have actually come across in your time?
So I must admit that, again, I don't have that much experience with the 2015 clause. When I was in practice, we used to see the 46 CP being used most of the time. And now in my current role, we're largely voyage charterers, so not that much experience. But I do echo Elaine's observation that, if I weren't in shipping and I look at a comprehensive clause like that, it would be a clause that I would like, subject to parties agreeing the parameters. But if I can, just allow me to make an observation. When I step back and I think about it, it's actually quite amazing how many disputes people have over speed and consumption. When you think about it, it's factual. Was your weather good? Did your weather meet, the parameters in the clause? It's the yes or no. There's no in between. There's no about. It wasn't. Both three. It's very factual. So why is it that there's so many disputes arising out of facts? And one, I think it's the clarity of the drafting. Parties are just not prepared to agree on clear terms, and they use phrases like about, which just adds to uncertainty. And secondly, I think it is the accuracy of the data. But I think on that second point, this is where I'm going to make a pitch for technology. As better technology and better analytics and better AIS solutions arise, these factual disputes ought to go away, because the facts should be irrefutable, as proven by contemporaneous evidence. So just something to think about when you have your next speed and performance dispute. Why are you disputing the facts?
Absolutely, I agree with you. I think technology can change a lot of these things, make it more clearer and accurate. In fact, the question from Captain Subhangshu Dutt, who's the chairman of the ICS Singapore branch here, who is deemed to be independent authority to determine weather conditions? I would say if we have the right technology, it has to be the technological innovation which has to be the right authority. But anybody can answer this question: who is deemed to be an independent authority? What has been the past legal cases or the awards in that case? What have they considered as independent authority to determine weather conditions? Who determines it? Is it the meteorological office, or is it some specific organization? I would like anybody to comment on this. Arthur or Suyin, anybody knows about this? Weather conditions determined by an independent authority. So who is the independent authority? Is it the local weather bureau, meteorological office? Who actually determines it? Okay, if we don't know about this, we probably have to come back to Kamdat on this. Is speed and consumption claim applicable if vessel required to slow steam or eco steam? So obviously that depends on the clause, I presume, but anybody else has different views, then please feel free to air them. Yeah, Jagmeet.
So no, not different view, but I think if the slow steam or eco speed, as we call, if those clauses, if those numbers are warranted, if that speed and consumption is warranted, not that the main CP speed and consumption is warranted and rest everything is only for, without guarantee, only for information. In that case, of course, there's a problem. But if it is warranted, then yes, and the ship does not perform, then you can go back with a speed and consumption claim, remembering that the burden of proof is on the charterer to go back and have a claim, not on the owner. But if it is not warranted, if it is without guarantee, then I don't, again, it becomes the same thing in good faith it has been given. Then you need to really prove that there is a lack of good faith.
Sure. There's another question from Ugar, which talks about what do you think effect of no swell term in good weather definition? If there is a term which says no swell, so the good weather conditions means no swell, that would be quite tough to then imagine that there is no swell in the first place. How would that come? That would probably come in favor of the owners, effectively, in this case, because Arthur, you have a point on that.
Just to say that any seafarer knows there's never any condition with no swell. So if you have no swell in the speed and consumption claim, I'm afraid there's no claim. It really is quite amazing that would actually find its way to a clause.
Yes, I agree 100%. Interesting observation from Jean-Marc Bornello. Would it be an option for owners to provide a speed consumption curve with a specific margin of error on the charter party rather than a single point performance in the performance clause? Possibly even different curves for specific bunk fuel numbers, or basically Beaufort numbers, Beaufort force. So I believe we have had this curve in past in some cases, especially on the eco speed and things like that. But I've not really seen that being very commonly agreed between the parties. Any experience from your side, Jagmeet and Elaine?
Yeah, not experience on that, but the question is quite relevant, and I would like to bring a couple of points in that. See, when we talk about speed and consumption, it is directly related with the frictional resistance of the ship and also the residuary resistance of the ship. I'm going a little bit technical, don't mind that, because without that, you cannot answer this question. So from one dry dock to the next dry dock, you know, the roughness of the hull will continue to increase till the next dry dock, unless you're a laker and you're going from seawater to freshwater and everything falls off. That's a different matter. But between one dry dock to the other dry dock, the hull roughness. So if you're going to have a curve which is going to rely on propeller law, and you keep reducing the speed and accordingly consumption is reducing, and you go ahead and draw that, then yes, it is possible. But how do you make corrections with regards to how many months you are out of the dry dock? That is why it is very, very important when you start negotiating right in the beginning. Don't wait till the CP details to start asking, when did the vessel have its last dry dock? What was done, whether it was in water survey or it was a full dry dock. This is very important. Hull resistance, frictional resistance, the roughness of the hull is extremely important. If anyone who is interested in this, I can send my article I wrote in, I think, 1993, performance analysis of a 12-year-old vessel when I was chief engineer on the ship, between dry dock to dry dock, how the entire hull frictional resistance changes. I think that is extremely important. It's not an easy thing to do for all the ships, just have a curve and put a point, okay, this is the speed, this is the consumption. It's not easy to do like that.
Right. Elaine, any experience of yours with a curve of speed consumption in your past positions in Norden as well as in NG?
Yeah, we before always use the speed consumption curve to evaluate the vessel performance, but I would say that's only good for reference. So it won't be really practical to attach this curve with a performance claim, because there's always some variance that could be caused by the wrong input on the deck log, or it could be the severe weather suddenly. What I oftenly see is that sometimes they would but it could give you good indication of the average speed, like what the ship actually can do. So yeah, but honestly, I don't really think the speed consumption curve will be quite practical when we talk when we have a speed consumption claim. No.
Right. Interesting. Well, there's obviously a question as to how much the owners wish to share, and it is obviously a commercial discussion. But if it becomes a more easy, and again, I think Suyin technology can make a big difference here. If we can actually see a lot more technology and clarity in terms of sharing of data, I think people will eventually start moving in that direction. There's a question from Mr. Anil Arora. The challenge for owners operators is what speed consumption to put in the charter party, especially for new buildings. These figures are to be based on warranted figures as per shipbuilding contracts, which are themselves similar, vague weather conditions, etc. And they are only warranted for ballast and fully laden at NCR conditions. And then, of course, we have to go on guesstimates. So I think, Jagmeet, you had answered this question earlier, and Elaine, you also had answered this question in terms of the fact that you have to maybe have a charter party clause which allows you to calculate the speed consumptions after a month maybe, or some time, and then maybe reevaluate the higher rate as well. Have you had any experience with these kind of clauses where you had to reevaluate the performance of the vessel after a few months of performing from the yard, and then reevaluate the hire as well? How do you do that? How easy is it? How practical is it?
It is practical if the duration is shorter. Say, for example, for the next 3 months or 6 months, if you're going to evaluate, then it does make sense. And there are a lot of things you have to have in that formula. You have to have the minimum duration of the voyage, and it has to be calculated very properly. Take out all the exception days, and accordingly you put the speed that you've got and the consumption in that formula, and you adjust your charter hire. It is possible to do it, but you have to be very careful and have a system in place to do it.
Right. Elaine, your experience is the same, that you actually do have these clauses, but you have to be very careful in how you actually word them, and clarity is super important. Yeah.
Yeah, actually, we do have these clauses, especially for the long-term time charter out. And we generally have, for the new building, we generally have 2 types of clause, either 6 months after delivery, or after 6 complete voyages, like a ballast plus the lagan. Because when we do the trial shipment, it's only ballast. Ship don't have any cargo. So the laden speed and the consumption is more like a calculative figure. And it's not that difficult to alter the higher, adjust the higher basis, the actual speed and the consumption, because now we have the IMOs, we have the glomerize. So you just change the speed and the consumption, replace it with actual figure, and resulting the same TC equivalent. You show to the charterers what is the difference, and if 2 parties can mutually agree on the new rate, then it's good. But it's always a commercial negotiation, up to the market. In case the market is keep going up, then charterers will just, happy to keep the original rate.
It's a commercial thing. I agree. There are
Exactly.
some very, thank you. There are some very interesting suggestions from Mr. Brian Williamson. Should CIS introduce an industry standard for resolving performance claims? It should not be too difficult. And why not consider expert determination? And in a related question, I would just like to get Arthur in on this one. Vasilev talks about how shall a sea state be described in a charter party to reflect the significant wave height if Douglas sea state or scale has to be dropped? What is the alternative? He wants to know, how do you describe the sea state and significant wave height if Douglas sea state is not there? And you mentioned it's not even there in Douglas sea state, but if you can just clarify, what is the alternative that they should mention in the charter party if they don't want to use Douglas sea state? Arthur?
Yeah, Douglas sea state, as you said, Punit, does not give significant wave height. It's not mentioned. So by putting in Douglas sea state, you're not actually putting in any wave height. And the answer is to put in significant wave height, not to exceed 2 meters or whatever it is that you wish to put in. Put that in the speed and consumption clause and drop this reference to Douglas sea scale because it doesn't actually help at all.
But is there an alternative scale which is available, or there is no need for an alternative scale as long as you specify the specific significant wave height that you want to put into the contract?
You already have the wave height within the Beaufort scale. So the Beaufort scale contains the wave height.
Exactly. So that's fine. So there is actually that's a good answer, because obviously the Beaufort force is not understood and used as much as clearly as it should. There's a question from Bastien Corbes. Could you please explain your view of how an off-hire claim due to a hull fouling on delivery is to be substantiated compared to substantiation method to be used when claiming normal underperformance claim in breach of speed and consumption warranty using a good weather thing? So how do you substantiate off-hire claim due to hull fouling on delivery compared to a normal performance claim? Any insights on this, Jagmeet and Elaine, probably from your side?
Let me find this question. I need to.
It's in the chat message.
Read it again. Oh, it's in the chat message or in the Q&A?
No, it's in the chat. It's from Bastien Corbes.
Okay. Could you please explain your view as to how the off-hire claim due to hull fouling? Hull fouling on delivery. So what Bastien, you're assuming that the ship has been delivered to you with the hull not being in the efficient state. So that is something which right from the beginning, it's not a part of speed and consumption claim later on. This is going to be the off-hire claim. So in that case, you carry out, I think, the calculation as you would, but then the claim would come under the off-hire claim and you won't give any benefit of the bunkers to the owner. That's the simplest way of explaining it.
Yep. Elaine, you have anything to add on that, or?
I don't quite understand why charterers want to take a delivery of ship when he already know it's hull fouling. If I'm the charterer and I know the ship already heavily hull fouled upon delivery, first I will send a message to reserve all my rights, like the ship is fully hull fouled, so all your guaranteed speed and the consumption is like basically no guarantee, so I can claim for whatever loss I would expect, something like that. So if the charterers want to claim under off hire, due to the hull fouling, it will be I mean it's not realistic or logical in my way, because if he have already reserved the rights, then all the speed consumption claim can just put on owner's account. Then it won't be under off hire clause. It will be under speed and consumption clause. That's my understanding.
Okay. Yep. So hope that answers the question. There's another question from Marco Metallic. I'm just going random in terms of question, trying to branch them together or bunch them together. Can one extrapolate, and this is a little bit to do with the measurement methods of the weather routing companies, can one extrapolate the performance during a good weather period over a whole leg? In my opinion, a calculated underperformance based only on the performance during a certain part of the voyage still remains an assumption. So can you extrapolate? Isn't that kind of the methodology which a lot of weather routing companies are using in terms of extrapolation of certain good weather periods over the whole leg?
Yeah, I think, Punit, what Marco might be meaning is the obiter that the judge gave in case of Ocean Virgo. And that is a very, very interesting thing, and also links what Suin mentioned earlier, that technology can do wonders. So if you have a way to model the performance and how the ship has behaved, so it could also be that you have a laden leg and a ballast leg, and you found just few hours of good performance in the ballast leg. You could, using that model, even you can calculate the loss which can happen or not happen in the laden leg, where the speed and consumption are very different from the ballast leg. So this is just an obiter. This is just something which we need to think about it, how these things can change over a period of time. How do we calculate the speed and consumption claims? So it's not there maybe at this moment, but going forward, if we have a way to model it, then I think what Marco is saying is quite possible to be able to do that.
I think, sorry, if I can just chime in there just one bit. I think as you were answering that question, a question came into my mind, which was actually what correlates to speed and consumption. Our clauses assume that it's sea state, it's wave height, it's weather conditions, but are those truly correlations when ships are getting more technologically advanced, and or do we need to relook at actually what truly impacts speed and consumption these days? I mean, we've not gone on to discuss alternative fuels even, right? So, what impact will all that have on these claims moving forward? So I believe this is just the start of our discussions on this topic.
Absolutely. This is a vast topic, and we are getting very much to the end of the webinar. Just one related question, which from Mr. Narsimhan in APJ Shipping. What is the minimum period of good weather that qualifies for extrapolating the entire voyage? Say, can 8 hours of good weather performance be used for a 14-day voyage? So this is, again, I don't know what is the actual precedent on this one, or any kind of guidance on this one, Jagmeet. What is the minimum period of good weather that qualifies for extrapolating for the entire voyage?
I think, again, the case law that we are looking at, say, in case of not exactly case law, but something which Ocean Virgo case. In that case, there was no 24 hours. There were maybe 16 hours, even less than that. So the term which was used was, is it significant? If that period is significant, it was coming to some 5.1% of the entire voyage. So I don't know what exactly law is going to be going forward. How many hours would be considered sufficient or significant to be able to calculate? Whether it's going to depend on the modeling, the technology, I don't have answer to that.
Thank you. I think we have run out of time. I think this has been absolutely fascinating discussion, especially this information or the revelation, I would say, from Arthur and Brian Williamson about the obsolete use of obsolescence of this Douglas Sea State 3, and the fact that it doesn't add anything is definitely something that I've learned from this. Also, the discussion on Sea Cargo Charter, and also revisiting some of these topics on the in night 15 and everything else has been completely fascinating. I would just request all the panelists to maybe give one line to end this discussion, saying that what is it that they want the panelists to go away with, one thing to remember from this discussion, what can they do to minimize their disputes going forward? So Jagmeet, you can start, Arthur, Suin, and Elaine.
Can I be the last on this one?
Okay, so Elaine, you want to start. One thing to go with, to remember, to minimize these claims. That'll be quite interesting, yeah?
Can I give two? I will be very quick.
Sure.
The first one will be that before fixing, it's either for owners or both and owners and the charterers always ask operation desk for the previous performance record of the ship. That's the first thing. Second thing is that when you appoint a weather routing company, make sure you don't only send the speed and consumption figure for them to do the auditing. Send the full CP clause you have. Okay, that's all.
Great, very practical. Thanks. Suyin, maybe you're next.
Yeah, I think two things really quickly. One, clarity in drafting. be clear on your expectations, both on the owner side and charterer side, and have that difficult negotiation. Second one, read your weather routing report to make sure it accurately reflects the clauses, and then take the negotiations from there.
Perfect. Yep. Arthur, your insights, sir.
Yep. I'll have two things as well. The first thing is something we see in arbitrations a lot: documentation. Make sure you keep the documentation and make sure it's accurate, make sure it's truthful, make sure it actually describes what it's supposed to describe. We see so many arbitrations fail because of lack of documentation, or even false, fraudulent documentation, which really kills the case. And the second thing is, when you're looking at this, talk to your P&I clubs. They've got so much information about speed and interruption claims, about recaps of the recent cases. It doesn't take, they've really laid it out very well, and it's very easy to read through and to really get some incredibly good guidance from. Okay, thanks.
Thank you, Arthur. Jagmeet, you're on now.
So Punit, you know why I said I want to be the last one. They have covered everything. So anyway, let me just say that you reap what you sow. Yeah.
Yep.
The seed is the CP clause. That's the seed. And it's difficult to always have a clause that is ideal for both the parties. However, minimizing the uncertainties and having a somewhat uniform interpretation may reduce the probability of disputes, loss of management time, as well as money and relationships. I think this is extremely important to remember. The clarity right from the beginning, information, as Arthur said, it's all there. Just that we are in too much hurry. Fix, and some more fix. Leave everything onto the operation manager's desk to clean the dash. That's what happens.
Thank you so much. And we will try and come back to you with the questions separately to the ones who have asked the questions, to hopefully come back to you with some answers. But this has been an absolutely fascinating webinar for me. I have learned many things myself, and I hope all of you have done the same thing. And I would just like to thank all the panelists. You guys have been really, really good, frank, and very, very fluid in terms of your interpretation and your views. So thank you so much. And I'll hand it back to Sharad. Thank you so much. Thanks a lot. Sharad, all yours.
Thank you, Punit. Thank you, all the panelists. It's taken a lot of effort and time of yours. It's really appreciated. I mean, we had more than 300 participants at one point of time and a load of questions. So I think that's made your day, I hope. We have to thank Vinny Chu from SCMA for all the technical support she has provided. As co-organizers, we also have to thank Singapore Chamber of Maritime Arbitration and Hong Kong Maritime Arbitration Group, as well as the Hong Kong Institute of Arbitrators. In addition to the organizers, we had a load of supporting organizations. To name them, China Maritime Arbitration Commission Hong Kong, Hong Kong Maritime Law Association, Hong Kong Shipowners Association, Hong Kong Center of International Commercial Arbitration, Vista Hong Kong, Young Professionals in Shipping Network, Institute of Sea Transport, Marine Insurance Club, Hong Kong Logistics Management Staff Association, the DMET MERI Alumni Association Singapore, DMET MERI Alumni Association Hong Kong, the CY Tung International Center of Maritime Studies, and last but not the least, Global Met. So we thank all of you for all of your support. And it's safe to say that going by today's response, we will definitely come back with something equally interesting in a couple of quarters from now. So thank you all once again, and wish you all happy vaccinations, I would say.
Thank you very, very much. Thanks a lot. Thank you.
Have a great evening, all of you.
Thank you. Thank you, Sharad. Thank you, Punit. I really appreciate, and everybody else, and especially Suin. Thank you so much. Arthur, Elaine.
Thank you very much.
Thank you.
Yeah. Thank you to everyone for attending.
Bye.
Thank you. Bye-bye.
Bye.